more pulse than other parts of the country. As an economic power, if we are being gradually, our laws, our strategy, our trade is going in the hand of something very big and somebody who is already a Dian in this field, and gradually, like other neighboring nations, we come to certain laws and certain regulations and try to become gradually in our economy goes in the hands of such countries which are mightier, which are superpowers, and which may not let us grow the way we should grow. So I think laws on the two coins. One side of the coin is we have to see that our laws and our ecosystem and our environment is conducive for trade and commerce and law. At the same time, we have to be very, very cautious about the way we are making our laws and our policies conducive. But are we not going in that direction, so that in due course of time we become sort of slave again in the hands of developed nations and the economies and the trade giants, or maybe international trade people, and we become sort of puppet in their hands. So we have to be very careful with, and therefore the people I know, IIFT people, my professor friend Sanjay Rastogi and all others, wherever we have people in international trade, my family members are doing business in international trade, and my people known to me, everywhere we are fighting with laws, and many times they are having a lot of apprehensions about the laws and regulations. But when I tell them these laws are in the long term going to be beneficial in this way and that way, so I expect one or two experts out here will show this side of law, which is to save the nation from the bigger sharks and fishes, is also very important. That is not the negative side. That is a cautious way of developing the nation. So I'm very honest in saying my thoughts about you. Laws and regulations and policies should be conducive for international things, but we should not be gradually giving everything the way we have given to East India Company. We should not be giving to all other people around. So sorry, this thought came to my mind, and I have spoken out my mind. I think this may have some relevance in today's discussion. And if I am not correct, I may be corrected, and I am really eager to learn from all of you. You are expert in your own field, but I have a little bit, insight about this as a student of strategy, as a student of law, as a student of policy. I have this much of insight on this topic. Thank you so much. God bless you all. Best wishes to all of you. And over to you, Mr. Ranjit Mohanty. Over to you. Ranjit, you have to unmute yourself.
Yes. Thank you so much, sir, for inaugurating this second session. We will look forward to future endeavors and discussions from you. You are the fountain of knowledge. Now I'll introduce the topic for the benefit of all. International trade, informally or formally, has always been the oldest of professions, businesses in the world. International trade and investments, including the evolution and making of substantive laws, are prevailing endeavors since time immemorial. Plato, Aristotle, Socrates, to name a few, pioneered this legal and paralegal theorization and execution as part of the duties and functions of the state. International trade and investments, commerce was most prevalent in the earliest of civilizations, such as the Mesopotamian civilization, Egyptian, Chinese, Indus Valley, and later on the Scandinavian and Europeans, along with the Japanese, took it to the next level, which is still prevailing, along with its negative byproducts also in the form of colonization and certain brutalities. The ultimate aim of being of this international business is the growth of world trade and investments. I myself can also cite some examples from ancient Indian facts of traders of Kalinga, that is modern Odisha, trading, selling and selling their products to East and Southeast Asian countries such as in modern Indonesia. Traces of international commerce of Bengal jute and Assam tea, doing business in Burma, Mongolia, and vice versa, can also be found in certain ancient texts. Modern trade, however, can be identified with the Industrial Revolution and later on with the Great Depression of the 1930s, which started or triggered the hardcore policy making and law making activity on a serious note in a global stage. As they all say, the barometer of degree of development of a nation is the other side of the same coin, and the other side being the economic development, which is also relying heavily on the international commerce, business, trade, investment, export, imports. This is today we are sitting on 11th September, and it's also remembered as the epitome of jealousy day. On this day in 2001, the World Trade Center was attacked to break down the economic backbone of the USA and also affect the whole world. It's remarkable that we are conducting this webinar on this international trade and investments and law on this anniversary of 9/11 today, graced by some distinguished speakers, academicians, and practitioners, including mentors in law and paralegal fields. Our first guest for the guest speaker for the day is Professor Soubhik Mukherjee. He is a research scholar as well as a research associate in NUGS Kolkata, which is a pioneer National Law University of India. Our keynote speaker for today is Ms. Trisha Mukherjee, who is Senior Associate Shardul Amarchand Mangaldas and Company, one of the top most powerful law firms in India, which have decided the fates of many corporates, including mergers and acquisitions, who will be addressing about the vital procedure and compliance aspects of international trade law. Our distinguished speaker for the day is economist Dr. Anju B. Mehta. She's a consultant Link Education Singapore, and she will be available in a short while. She's her global class is going on, and she will be making a little bit appearance, and she has sent her apologies for that also. The second guest speaker for the day is Supreme Court of India Advocate Shashank Shekhar Rai, who is also a partner of and founder and partner of the Logical Bridge Law Firm, New Delhi, who will be speaking especially on MARPOL, that is marine pollution aspect in international commerce and business, and how it has also to be taken into account. Now I would welcome Professor Soubhik Mukherjee, because I know Professor Soubhik was my colleague in Amity University, Kolkata. So he was also there in Goa, and he also served in Amity University, Kolkata, as well as Govind Ram Kare College of Law, Margao, affiliated with Goa University, and is currently the research associate and scholar at Center for Regulatory Studies, Governance, and Public Policy in the prestigious West Bengal National University for Juridical Sciences. Prior to venturing into academia, he practiced law at the bar for over 5 years. He was associated with Menon Associates and Justicia Law Offices. He represented corporate and individuals alike before several forums across India, primarily before the Delhi High Court. He acted as advisor to several multinational companies on contemporary international trade-related issues, such as cross-border insolvency, prevention of money laundering, and ancillary legislations. He has a keen interest in development of the law in the wake of unparalleled technological advancement in the information technology sector and international law in general. He has qualified the UGC NET in 2017. He did his LLM International Law from Faculty of Legal Studies, South Asian University, New Delhi, which is an university established by SAARC nations. He received a full scholar for pursuing master's degree in law from South Asian University, New Delhi for the academic year 2015-16 and 16-17. He also had a scholarship which included the waiver of the full tuition fee, rent-free accommodation, and monthly allowance of 5,000 rupees. So he is a brilliant scholar to get such scholarships. He also received scholarship from West Bengal government while attending the school at Rashtriya Indian Military College at Dehradun. He did LLB from the Faculty of Law, University of Delhi, in Delhi, India. He is extensively involved in research and mapping of provision relating to the quantum of expropriation in the Indian bilateral investment treaties, research and mapping of South Asian bilateral investment treaties in accordance with the provisions, research and mapping of provision relating to intellectual property rights in Indian bilateral investment treaties, and tips. So I'll welcome now Soubhik to take over and give his.
Ranjit sir has been too kind. Actually, I'm not professor at the first place, and he has been too kind. And he actually almost like full of my CV has been read out, and I feel very humbled and rather a bit confused with so much of introduction. I don't deserve so much of applause. I would say I'm just a research scholar. I'm a learner. I have specific interest in investment law particularly, and my research area is also designing of investment treaties particularly. As VC sir from RGU stated, he made valid points like we have to be careful about the developments, we have to be liberal, but the liberal should not be of such nature that we completely compromise ourselves. This is a very important point he picked up, and I believe even though he said that he is not from this particular department or this particular area of law, I feel if you can sum it up, this is what it comes down to. I'm going to talk about the issue of designing of investment treaties or bilateral investment treaties and the model investment treaties in this particular generation at this point of time. Now, if we look at the newspapers at present time, if you flip about a couple of days back, you will see there is a news on Keynes Energy. And if you flip about 3-4 months back, you'll again see Keynes Energy taking properties of Indian government's property in France. And presently it has been settled for $1 billion of Indian taxpayers' money. Now, if we go a bit more deeper inside, for the students specifically, I would like to say that, if you go a bit deeper, more than just the news, if you go deep inside, you will find this particular dispute is because of a retrospective tax imposition by the Indian government upon Keynes Energy. And this imposition was considered to be a violation of fair and equitable treatment, which is a provision in the bilateral investment treaty between India and UK, which was signed quite long back. Now, we have taken certain measures. Like, if you have to understand, first of all, that as a country, we are moving through a continuum. It's not that break and we are moving. It's like government is changing doesn't mean the country has stopped functioning. It is very essential for all the countries to understand when it's a continuous movement of a particular country, then the policies taken by a previous government should be followed by a following government, even though you may not agree, because the commitments you're making at international stage is quite devastating. We don't understand the cost of investment treaties unless and until actually we face with certain penalties, like the present case of Keynes Energy. We also have heard about, probably some of you have heard about a major case, landmark case in Indian about investment treaties, that is White Industries case. It's changed the landscape of investment law all across India. We changed our approach towards investment treaty after that particular case, arbitral award rather. Now, when we talk about bilateral investment treaty, I'll just take you back a bit behind and then come to the main issue, what I'm trying to say. I have a very simple point, what VC sir was talking about. I can just finish up within one sentence, but finishing off within one sentence of the issue may not solve it, because we have to understand the system of investment law or investment treaty as such. So bilateral investment treaty are the treaties which is a part of a larger scheme of things, that is international investment law. Now, what is international investment law? If you look at it on the face of it, it is part of international law, public international laws rather. Now, however, it is not exactly public international law. It is a separate discipline. It may be part of it, but it has certain other elements into it. To begin with, if I have to start with the international economic law, that plays a significant role in it. And when we're dealing with international investment law, there's another factor, there is a domestic factor into the picture, which is not often taken in consideration in case of international law exclusively. When you talk about investment law, there's a peculiarity of a particular domestic features are incorporated in this particular scheme of things. The other end, we have to look at it like from the perspective of the source of law. Some of you have studied maybe in your public international law classes that source of international law happens to be from Article 38 of ICJ statute, and it lists treaties, customs, general principles, and precedents being the secondary and scholarly work. But when it comes to investment law, it is just not limited to that. That's because it depends on how you look at investment law. For example, if you define international investment law as international law and investment, if you define it this way, if a particular individual decides to talk on this understanding, then yes, definitely it's part of investment law and you can use Article 38 and that's the end of it. But if you decide to define international investment law as foreign investment in your domestic territory or foreign transaction, if you look it from the domestic perspective, the approach changes. The moment the approach changes, the sources of law ends up changing. You have domestic plays coming to the picture, domestic rules coming into the picture, even private international law coming into the picture when you look from this top-down approach. If you look from the a top-down approach, it's international law. If you look from bottom-up approach, it becomes more than just international law, with several other sources playing a key role in development of this law. There's another factor which is often included by some of the scholars, that is the who is looking at this particular law. If a person from international commercial arbitration background is looking at this particular investment law disputes, he would be looking at it from a perspective of how they approach commercial arbitration altogether. And that involves a lot of domestic legislation in the picture. So this also plays a role. And unlike the international law awards or ICJ awards, you would see that in investment arbitration awards, there's a lot of reference to the preceding awards. It's not something which has reached to a status of jurisprudence constante, but still the arbitral awards, maybe in order to bring uniformity in the practice, maybe they've come from the same school of thought, they actually impose a lot of preceding awards and incorporate those principles in the current awards, which is not a mandatory thing in international law per se. So if you look at it, it is quite complex. It's not that simple. International investment law is not at all simple. It has several factors in the play. It has domestic players in the play. It has international law as a part of it. So we have to study this subject very carefully when we do that. And because all these while, since till 2000 rather, there's not much of dispute on this particular subject. There was not much of, it's only Argentine financial crisis which brought this particular subject into the center front. Now, earlier it used to be on the fringes of international law. Now, when this awards came, this arbitral awards came, which turned out to give awards in favor of the investors against the measures taken by the government. For example, a taxation is imposed, but that taxation seems to be illegal. It's a sovereign power of a nation to actually impose tax, but you can't do it because you have signed a treaty at international level, which they did not realize at the initial stage while signing this treaty. It's only around 2000 they started realizing that importance of this particular subject, and there is some problem with the designing of the treaties which they have signed. Now, again, if you have to look at the designing of the treaty, we actually have to go back at the very beginning. The earliest of the bilateral investment treaty was in the year 1959, I believe, between Germany and Pakistan, and thereafter it grew in a moderate pace. But in 1990s, there were like almost 2,000 BITs signed during that decade of 1990 to 2000, basically post-Cold War. Now, maybe because the reason is countries, the developing countries, the underdeveloped countries, they thought or they believed in this principle that if there is foreign investment, you are going to have economic development. It's something which moved them, the idea of economic development. And foreign investors wanted to protect their investors when they're investing in a foreign country. That is the basic premise of investment treaties altogether. So when we talk about at the initial stage, when in 1950s, around that point of time, 1960s, there was an effort by world community to establish a multilateral framework, just like GATT in trade. There was a multilateral framework. Similarly, to form a multilateral framework with respect to investment law too. Unfortunately, that was not successful because most of the nations had just received freedom from colonial rules. If they did not want to get into that kind of engagements where our foreign investors are coming and investing on their land. However, they wanted to have economic development. So what they did, instead of going development, had better understanding of the subject and they had better research on the subject. In such a fashion which protects their investors to a great extent, with very limited rights of the host states at that point of time. Anyway, they signed it. They did not realize the cost of it, including India. Nobody realized the cost of it over the period until unless there was an arbitral award which went against the host countries. So after they realized it, they decided, okay, now we have to think again. We can't just go on with this particular designing because it seems that it is completely biased towards the investors, and my rights are being hampered. My sovereign rights are being hampered. So even the developed countries, because initially there was only one-way flow of transactions in terms of investment, so it was different in nature. But presently the transactions are also two-way. So even the developed countries, they thought maybe it's time to have a relook at the investment treaties or the model investment treaties. So now, how do you look at investment treaties? ideally, there is a theory established by Barbara Cormanis and few others called rational design theory. She had undertaken a project on this in year 2001. Now, this project philosophy was that they basically claim that a particular country gets into a treaty practice only when they feel their need is being fulfilled, the collective need of that country is fulfilled through that particular country. Now, when they did this study, they did it upon the multilateral regime primarily. However, under my studies or my understanding, I, and in my understanding, I believe it has to do more with the domestic field also. Domestic, as in, I'm sorry, with bilateral field also, because with bilateral treaties, it is much more severe, much more important to have as fast as possible. The thing is that this theory needs to be applied in bilateral investment treaties too. But while the developed countries decided to take the theory, do research, develop their model treaties, the developing countries what model investment treaties these developed countries are creating. Now, what is happening is I came across a particular treaty which was of such nature that they have ripped off even the name of the other country. They could not even get a proper copy paste in place. There are scholars who stated that unless and until you have enough research funding, enough work towards this particular subject area, you should not engage with this regime, because you do not know what is the cost of this particular regime, which is going to happen later, maybe 10 years, 20 years later. So one has to be very careful. So I would like to conclude that it's not my prerogative to determine what your approach would be. You can have liberal approach, you can have conservative approach towards your country, depending on your needs. But what you need to do, if before you sign this treaty, have a proper research. And if you cannot have a research, do not try to change anything. Do not engage with this regime, because it may cost you dearly and deeply. I think I should conclude, because I believe I've crossed my time. Ranjit sir? Or if you want me to go on, I can go on.
No. It's okay. You are because the topic is very vast, and academicians don't have that time limit. They can speak, and you are an expert. I know that. I also followed international law in your footsteps to some extent also, and in maritime law also. Now I would thank you, Shobik. We'll get back to you with the questions also.
Thank you for the opportunity.
Now I will now. It's my pleasure to introduce and invite Ms. Trisha Mukherjee, who is a senior associate in the dispute resolution practice group at the Shardul Amarchand Mangaldas and Company. She is a brilliant, studious student throughout her career. She was a career first class, and she did her international law. She handles the corporate commercial disputes arising out of construction contracts and commercial contracts. She represents clients in various courts and tribunals, including the NCLT and the NCLAT also, I believe, National Company Law Appellate Tribunal, High Court and the District Courts. Trisha also handles complex domestic and international arbitrations. I welcome Madam Trisha to the meeting and to address and give some tips to our students who will definitely look up to you as a mentor or professional mentor, or career gurus, because you people are there in the action part of the industry. I welcome you once again. Please address the students.
Good afternoon, everyone. Firstly, I would like to thank Dr. Ranjit Mohanty sir for inviting me to this extremely interesting webinar today. I am glad to share the platform with some very eminent speakers, and I will briefly speak about the regulatory and compliance aspect of international trade law. So, in today's economically interdependent world, it is very crucial to develop and maintain a cross-border legal framework. And it is mainly for the facilitation of the trade and investment. Now, as we are all aware that due to the COVID-19 pandemic, we have all witnessed an unprecedented disruption, which is caused due to the global economy and the trade worldwide. Now, the export import has also been like badly affected. So even though the like now, if you look at the goods barometer of the World Trade Organization, you will see that there has been recovery. However, in the first half of 2020, we had seen a number of challenges, and which was mainly faced due to the pandemic. There were lockdowns, and it had impacted the supply chain. It had impacted the availability of labor to unload the ships at the ports. Now, generally, all the supply chains were affected due to the additional health and safety measures which had to be taken for all the participants in the supply chain. Now, there were limits on the mobility of people, and lockdowns had a variety of trade processes which had to be implemented, like the physical inspection of goods for the sanitary and the phytosanitary measures, testing and certification for technical barriers to trade. Then there are anti-dumping investigations which were being conducted. Now, coming to the compliance aspect of it, the Director General of Foreign Trade, which is DGFT, under the Ministry of Commerce, is the apex body which regulates the imports and the exports and ensures the trading is in compliance with the foreign trade policy. Now, a foreign trade policy provides a set of guidelines which helps a country to achieve its domestic production and export goals. Recently, there is the FTP 2015 and 2020, which is so it is for 5 years, which is implemented the foreign trade policy. Presently, it is the FTP 2015-2020. Although this policy had expired in April 2021, it has been extended till September 2021, after which there will be the foreign trade policy of 2021 to 2026. The other part is India is a party to several regional trade agreements, which are the RTAs, and the preferential trade agreements, the PTAs. Now, what is an RTA? India has RTAs with its neighboring countries like Bhutan, Nepal, and Sri Lanka, and other Asian countries like Japan, Malaysia. Now, India shares a preferential market access and economic cooperation through trade agreements with over 50 countries. India's import and export system is governed by the Foreign Trade Development and Regulation Act of 1992 and the EXIM policy, which is the export-import policy. In the last decade, we had seen that India has replaced several licensing and discretionary controls over the import with deregulation, and now we have much simpler import procedures. Like most of the process is now online. You can, for compliance, you can file the application, the license through online mode. So presently, most of the items which are imported fall within the scope of the regulation of the Open General License, which is the OGL, under the EXIM policy. This means that these goods are deemed to be freely importable without restrictions and without a license. And then there are other categories which is beyond this Open General License. For example, the banned or the prohibited items, the restricted items which require a special import license, and the canalized items. So for the first category, which is the banned or the prohibited items, if I would give an example, it is like rough diamond. Now, rough diamond is permitted to be imported to India only if it has a Kimberley process certificate, which is an extensive process, and it is mainly for regulating the transparency and oversight in the diamond industry. So that falls under the category of the banned or the prohibited items. The second category is the restricted items, which require an import license. For example, if wildlife animals are imported under the Animal Exchange Program, you have to file an application for import license for the restricted item. Now, you can go to the DGFT, that is the Directorate General of Foreign Trade website, and you can pay the requisite fees and upload documents like permission from the Central Zoo Authority and wait for approval. So those fall under the category of restricted items which require the import license. Once you get the approval from the DGFT, you can import. The third category is the canalized items, which are only available for the government trading monopolies, which are subject to the cabinet approval. So canalized items would be like vegetable oils, agricultural products, and some pharmaceutical products. Now, export shall be free except when it is regulated by way of prohibition, restriction or exclusive trading through the straight trading enterprises. India has a trade classification which is an harmonized system which is called the ITCHs of export and import. Now, next will a very interesting part is the labeling and the marketing requirements for the food products which are imported to India. So, from the compliance perspective, it is the Food Safety and Standards Packaging and Labeling Regulations 2011, which is regulated by the FSSAI. Now, presently, there is a new food safety standards labeling and display regulations of 2020, which will come into effect sometime later this year. These regulations are quite exhaustive, and one example of this would be when you're importing food products, the importer shall have to display the FSSAI code, the logo, the license number, the name and address of the importer. The country of origin of the food shall also be declared on the label of food imported to India. So, compliance of these regulations must be ensured before the import consignments are declared by the Central Board of Indirect Taxes and Customs. Now, another aspect which I would like to talk about is the trade remedial investigation. In India, all the trade remedial investigations are conducted by the Directorate General of the Trade Remedies, which is DGTR, under the Ministry of Commerce and Industry, which is chaired by a designated authority. Now, what do I mean by the trade remedial investigation? Trade remedial measures like anti-dumping, anti-subsidy, and safeguard are major instruments which are provided under the World Trade Organization's framework to its member nations to protect their domestic industry from the incidence of unfair trade practices and unforeseen surge in imports. India has been a major user of these instruments. So, for anti-dumping measures, now if an anti-dumping duty is imposed against the unfair imports to India to remedy the injury caused to the Indian producers, in India an investigation is carried out by the DGTR, which is the Directorate General of Trade Remedies, under the Ministry of Commerce. Now, recently, if I would give an example, it would be India had initiated a probe into the increase in the subsidized imports of copper tubes and pipes. Now, copper tubes and pipes, as in the ones used in air conditions and refrigeration system. So, these copper tubes were imported from Malaysia and Thailand. Now, what happened is that the domestic manufacturer, namely Bombay Metal Exchange, had given a representation to the DGTR stating that there is a steep decline in the production due to jump in the import of these copper tubes from Malaysia. Now, why did this happen? Because of the significant subsidies and the benefits that were available to the producers in these countries. Now, after receiving the complaint, the DGTR had initiated countervailing duty investigation. In this probe, the directorate would determine the existence, degree, and effect of the alleged subsidization and recommend the amount of countervailing or anti-subsidy duty which is levied and which would be adequate to remove the injury to the domestic industry. In addition, India is also currently pursuing trade remedial action against the Chinese producers, with government banning these Chinese apps and introducing restrictions on the public procurement from China. So, under the international law, anti-dumping measures are regulated by the Article 6 of the General Agreement on Tariffs and Trade. In India, the anti-dumping actions are regulated by the Customs Tariff Act. Now, if I would briefly give an example of recently concluded investigation by the DGTR, it concerns the anti-dumping investigation in for the vitamin C, which was being exported from China. Now, what happened is that Bajaj Healthcare Limited filed an application before designated authority, that is of the DGTR, and in accordance with the Custom Tariff Act for initiation of an anti-dumping investigation and imposition of anti-dumping duty on imports of vitamin C, which was exported from the People's Republic of China. Now, what happened is that the investigation was carried out and ultimately it was found that yes, the domestic industry, that is India, had suffered material injury. considering the normal value and the export price of the subject goods, the dumping margins and the dumping margins of these subject goods from the country, there was an order that the domestic industry was significantly affected. Now these orders are of course appealable, and you can file an appeal before the customs, excise and service tax appellate tribunal. So this is one example of a very recent case on anti-dumping duty. Other than that, the second aspect would be on the countervailing duty, that is the anti-subsidy duty, which is also known as the countervailing duty. That is imposed to counter the subsidization by the foreign governments that lead to cheaper, unfair imports that cause injury to the Indian producers. So in India, it is regulated by the countervailing rules, which was enacted to determine the subsidized articles liable for countervailing duty, and these are under the the imposition and collection of these duties are under the designated authority of the Ministry of Finance, and these duties ceases to have effect on expiry of 5 years from the date of imposition of the duty, unless it is revoked earlier. So next aspect would be on the World Trade Organization has a dispute settlement system, and India is one of the main, India is involved in a number of trade disputes at the World Trade Organization. Most of these are either, in India is either a complainant or the respondent, and most of these cases have been with USA. And these disputes include imposition of the tariff or the anti-dumping duties and violation of basic principles, such as the most favored nation treatment. So recently, the World Trade Organization has set up 2 more dispute settlement panels at the request of Japan and Taiwan, targeting the import duties imposed by India on the ICT, that is Information and Communication Technology products, including mobile phones. So I would wrap up with an observation that, since I'm in the disputes practice, there's a growing trend with the international dispute landscape, and as one of the fastest growing economies, India is a hotbed of opportunity for international investors. If you have any questions, you can email it to me and I shall be happy to discuss. Thank you.
Yes, thank you, Trisha, ma'am. We'll also take up the questions if anybody has in the chat box. The audience can put their questions in the chat, or we'll take it up at the end of the last 10 minutes. It's at the end. Thank you so much for sparing time for the young generation, for the students who are our future tomorrow. And we are really grateful to you for having accepted our invitation and sharing such insightful thought on the practice and compliance aspects, comprehensive
Thank
and
you,
such
sir.
big
Thank you so much.
Thank you, Rishabh. We'll get back to you. Now I would like to welcome Mr. Prashant Shekarai. He's a bright, young and international legal consultant. He's a master's from Center of Postgraduate Legal Studies, Global University, from the Tata Institute of Social Sciences. He did his BA LLB from Bangalore Institute of Legal Studies, Bangalore University. At present, he is the founder and partner of Logical Bridge Associates and advisor, a multidisciplinary law firm offering legal services in areas of policy, research and drafting, consultancy and advocacy to top Indian corporates, Fortune 500 companies, multinational banks, financial institutions, governmental and statutory authorities, and multilateral and bilateral institutions. Few of his leading clients are to reckon with are Reliance BP Mobility Limited, Danish Housing Society Bhopal, India Land Development Private Limited, National Institute of Technical Teachers Training and Research, autonomous body under the Ministry of Education, Government of India. He has earlier been an international legal consultant to International Solar Alliance, an international intergovernmental institution initiated by Government of India and France for promotion and scale-up of solar energy in UN member countries. While working with the ISA, International Solar Alliance, He successfully drafted headquarters agreement between the Government of India and the International Solar Alliance and other foundational documents of international nature. With diverse experience of working in courts, law firms, and international organizations, he brings competencies in engaging with various stakeholders on legal issues with effective application of legal prudence. We welcome you, Mr. Rai, to enlighten us with your talk and especially role of MARPOL, that is marine pollution, and its policy and the law in international trade, its role in the international trade, because as we know, force majeure clause involves many of the marine pollution, and even the corona pandemic is now part of the force majeure clause. So the stage is yours, Mr. Rai.
Thank you so much, Professor Mohanty. It's been such a privilege to be part of this esteemed discussion. Thank you so much, VC RGU. And yes, so basically when we discuss about international trade, I would like to say that we cannot study the international trade in this whole gamut of investments and transportation in isolation. When we say international trade, there are allied international environmental legislations which come into picture. Now, oceans, especially being the primary source where bulk of the transport happens, there are high chances that pollution is bound to happen in the ocean, and marine life might be disrupted. For example, we take on the case on Exxon Valdez case. It was a landmark case where around 4 to 5 lakh species of bird to marine animals were found dead, and it was a US company which accidentally had met with the accident in Atlantic, and around 11 million gallons of crude oil was discharged in the Atlantic Ocean. Thereby, its ramifications are still present till today. Similarly, a very important case from India, the Chennai oil spill case, is also there. So considering this, all the nation states have came up with intergovernmental organization. They have joined hands together to formulate international organizations to specifically deal about marine pollution. Now, MARPOL basically refers to marine pollution, and MARPOL was developed through the International Maritime Organization, and which deals with maritime security as well as pollution from obnoxious gases, oil spills in India. Presently, MARPOL has around 168 signatory countries, and 158 countries are those countries which have also ratified their instrument. India is one of the parties of the MARPOL. Now, this is one of the very, very important conventions when it comes to marine pollution, and currently, there are around 6 annexes which are the part of the MARPOL. The first annexure being the regulation for prevention of oil spills, and under this, the MARPOL under this, MARPOL has formulated certain regulations through which the discharge, a list is appended to the regulations under which the discharges from the ships has to be regulated under the sea. Similarly, then there are other annexures, for example, regulation for the control of pollution by obnoxious liquid substances in bulk, and this came into force in 1983, and it deals with detailed discharge criteria, and around 250 substances has been appended to the regulation. Then similarly, there are other annexures which concerns to air pollution emanating from the ships, and it is very interesting. I will quote this very important data where the shipping sector accounts from around 12% of the global sulfur dioxide emissions, and 13% of global nitrogen oxide emissions, and 3% of global carbon dioxide emissions worldwide every year. Therefore, this regulation becomes very important. However, now the most important facet in international law is the enforceability clause. And as we all know that these international organizations are part where nation states meets and discuss, negotiate on various aspects, though the clear enforceability clause is not defined yet, and therefore even till now, now that the liability on oil spillers and other companies which are discharging or discharging obnoxious substances in the oceans is not regulated till date. That's all. Thank you.
Yes, Mr. Rai, it was very brief, very brief. The regulations are, yeah, I know it plays a major role in the transit of international trade and commerce. As you told that the ships are the prime source of carrier of cargo, and there are, bunker oil. They throw the bunker oil in the high seas, and there are oil spills. There are ship collisions. There are pirates, ship pirates, armed robberies in the seas, so many things. But I think Marpol was separate organization which was created only to take care of the marine pollution and not to harass the marine creatures which are under the sea and the seabed in the economic zone, as well as the contiguous zone, and also in the territorial sea, and also in the high seas also. So, and there are some nuclear wastes now. They are also being disposed of by certain developed countries. And there is a hue and cry that Antarctica is, like it is melting due to this, the heat of that nuclear disposal in the high seas just above the Antarctic, this continent. So there are a lot of, I know I am a teacher of law of the seas. So there are so many contentious issues. There are, like Madam was telling about phytosanitary, that treaty on PHP, phytosanitary and other things. So foodstuffs, these are all part of the WTO 15 agreements, that subsidiary agreements, or the 15 agreements of the WTO, which was the transition from the GATT to the WTO in 1994. And there are still some certain countries which are not signatories, certain countries which are planning to leave the WTO framework, including the United States. During the Trump administration, they also wanted to now have their own organization, being a big member of the UN also. So I know it is very big topic, and it cannot be covered in such a short session. So I just wanted that our
Yes, sir.
students should know that the international arena is so, full of career opportunities and so full of ample opportunities in various kinds. And now this foreign law firms are also coming. That is also part of international business now. And Indian law firms also, like Luthra and Luthra, Amardas Mangalchand, these people, they are also doing business in international locations. They are having branches in all other countries also, other continents also. So this is part of international trade. And I think we have to wrap up the session now, because it is a 1 hour session. We'll definitely meet in a individual, because single sessions, because Shobik also is very, sentimental. I know he carries his classes 1 hour class to 1.5 hours. Other teachers used to miss. I was his colleague, I know that. And Madam also, Trisha Madam is also very anxious to speak more, because these students also will not learn more if you give them in bulk. So they want like one spoon by, one bite by bite. So that is why we call it the legal bites. So I will now invite Miss Madhumita, who is a student of the postgraduate department of Savita Law School, to give the vote of thanks for today's session. Yes, Madhumita.
Yeah, sir. So, very good evening, all. I deem it a great honor and privilege to deliver the vote of thanks on this memorable occasion. This day will be remembered in the milestone of our webinar diaries. On listening to these enriching lectures, I trace back to the inspirational quotes of an Albert Einstein, who aptly said that information is not a knowledge. The only source of knowledge is experience. So you need experience to gain wisdom. So I extend my hearty thanks for the speakers for sharing their wisdom. First and foremost, I like to extend my sincere thanks to SOA University, Royal Global University, Savita School of Law, and Savita University, and Reva University for co-hosting and providing this global webinar seminars for young budding lawyers. I would also extend my sincere thanks to Professor Dr. Sanjay Pratap Singh, the Vice Chancellor of Royal Global University, for blessing this occasion. I would also like to thank Mr. Sovik Mukherjee, the Research Associate, for his eye-opening speech on trends on international trade and developments. I would also like to extend my hearty thanks to Ms. Trisha Mukherjee, the keynote speaker, for her inspirational speech on the trade regulations and also on the regional trade agreements on WTO. I thank and also extend my hearty thanks to and gratitude to Mr. Shashank Rai, the Advocate of Supreme Court of India, for his explaining his international trade problems and the current oil spill problems in current international trade is concerned. I also extend my warm gratitude to Dr. Rumi Ahmed and coordinator of Royal Global University, who, in spite of their busy schedule, allocated time for us to grace this occasion. I would also like to extend my sincere thanks to our beloved Chancellor, Dr. N.M. Veerayan, and our Principal Ma'am, Dr. Asha Sundaram, for their support, vision, and commitment. My hearty thanks to Dr. Ranjit Mohanty for his valuable contribution in moderating this session. Last but not the least, I thank my friends for your cooperation in making this event very resounding success. Once again, I thank you all.
Thank you, everyone.
Thank you, everyone. Thank you.
Thank you,
Thank you,
everyone.
Madhu.
Thank you, Madhu.
Thank you, sir.
Thank you, everyone. So we look forward to another session on the last week of September with another new topic, which may be either maritime law or sports law. And I welcome all the participants to join them. We'll share the joining link and the creatives in some time in a few days. Thank you all. Thank you all the panelists for sparing time and addressing our students of 4 universities. Thank you all. Have a nice weekend.
Okay. Thank you, Dr. Mohanty.
Thank you, Dr. Mohanty.
Thank you so much.
Thank you, everyone.